Okay. Well, good evening, everybody. I'm Leah Rachin and town attorney. And I know Keith had said that some training may be in order. I know some of you are probably well acquainted with these concepts. Some of you are new and might not be. So bottom line is it's a refresher for some. It might be new to some of you, but um, there are a bunch of different concepts as just generally speaking as municipal board members, but again, it's specifically towards the zoning board of appeals that you should be aware of. So basically tonight, what I'm going to do is cover several issues, just kind of, I'll give you kind of the framework of what we're talking about tonight. So first things are these threshold issues before you even get into the appeal itself. Issues like jurisdiction, standing, right title and interest. These are basically the kinds of hoops that folks have to jump over before they can even get in front of you. The second sort of grouping of thoughts relate to the decision-making process itself. So once you're in it, the kinds of things you should be thinking about, the standards of review that you're looking at, that'll be different from, appeals than it will be for variances. So we're going to kind of parse those out too. The next thing we'll talk about is FOA, Freedom of Access Act, otherwise known as the Right to Know Law. That's a really big part of your job. It's kind of always operating in the background. And I will say that in these times of, oh goodness, conflict, right? And a lot of people are very suspicious about their government and what boards are doing. That I'm seeing a huge increase in public records requests. And so that's something that you think, well, what does that have to do with me? We'll talk about what that has to do with you, and sort of traps for the unwary that you should be mindful of. And the most important thing I will say are your questions. This is a small group. It's always so much more interesting. If you have a question that pops into your mind, ask it. Let's have a discussion rather than me just yammering on at you, okay? Um, and the only thing usually when I talk about questions, I usually say, but if there's any pending applications, let's not ask, let's ask general questions, not specific ones. But it sounds like you don't, as far as I know, Keith, there's nothing pending right now, is there?
Nothing pending. We had an application on that. I reached back out to them now that the other.
Oh, you have a quorum of the board, yeah.
And they have not on.
All right. Well, no news is good news, I guess, right?
Yeah.
Okay. So let's just talk about those threshold issues that before you even get to the meat and potatoes or whatever's in front of you that have to be met before you go there. Okay. The first thing is jurisdiction. And basically that means that you as a board have the authority to address the application in front of you. And this is something where, this is the mantra under Maine law that municipal boards are what they call creatures of statute and ordinance, which means they only have that authority, which is specifically enumerated either in statute, charter, or a local ordinance, right? So even though obviously you're all very devoted to public service, if somebody comes to you and asks for you want to help them, right? But you can't necessarily help everyone. And you have to look within the four corners of the ordinance to say, hey, am I allowed to grant the relief that you're seeking here? Okay, so that's the first thing. And under the land use ordinance and in your materials, I've kind of given you what are the sources of your authority. And they're really kind of, I would say, twofold, right? You've got the charter, which basically says we have a board of appeals. That's not super helpful, right? Then you have two provisions under Title 30A. And 30A, you'll hear, like you've probably heard, you'll see citations, 30 MRS, right? So MRS means the Maine revised statutes. Title 30A is kind of where all the municipal stuff is. So the first thing is section 2691. That is basically the general statute governing boards of appeal. And that talks about jurisdiction, talks about process, and the town's land use ordinance, and we're going to get into that, section 11, really gives more detail. But if there's a procedural issue or question that isn't specifically talked about in your local ordinance, you look to 2691 and it'll hopefully give you some guidance as to what to do. The second important statute that relates to your authority is 4353. And that talks about zoning boards of adjustment. That's just the old fashioned term for the zoning board of appeals. And that's where all of the statutes, or sort of the provisions relating to variances and the different kinds of variances and the different standards that you have to apply for the different kinds of variances are articulated. If you do kind of a compare and contrast to the town's ordinance to the state statute, here they match up quite a bit. There are a few kinds of variances that the statute allows if a town adopts an ordinance, which this town hasn't, so we can cross those off the list, but we're going to go through those. Okay, so let's talk about the biggest source of your authority. And again, those statutes that I talked about pretty much provide the framework, but your ordinance really fleshes that framework out. Okay, so the first area of authority, let's go to, and you don't have, we're not going to read it verbatim, but if you go, the biggest source of authority is aptly named the Zoning Board of Appeals, and that's section 11 of your ordinance. Okay, and so let's talk about, these are the kinds of appeals and variances that you are going to be dealing with. The first are what we call this under section 11.31. These are the administrative review and interpretation appeals. And essentially what those boil down to are appeals of code enforcement officer enforcement decisions, okay? Under Maine law, it allows towns to decide, you know what, we don't want appeals of enforcement decisions because whatever, they just think, you know what, that's a lot, we don't want to have them. Other towns like Arundel have decided, you know what, we do want that. We want to check and balance regarding enforcement decisions before they go to court. And so this board does have authority over enforcement decisions. When I say that, that is code officer issues a notice of violation, okay? If I'm the property owner to whom that notice has been issued, I have the right to appeal that to you to say, I didn't violate. And so that is one of the things that you are looking at. Now, up until recently, when I say recently, getting long in the tooth recently becomes like 5 years or 10 years, but there was a case out of York, and it used to be the case that, yes, of course, I, as a alleged violator, can appeal. But it used to be the case that usually, and you probably have seen this in a small town, there's folks who are mad that they think there's a violation, the angry abutter essentially saying, this guy's running a junkyard off of his property, do something, code enforcement officer, do something. And the code officer doesn't do, or does, I shouldn't say that. They will write back and say, I don't think this is a violation. That determination of failure or there's the enforcement, but the failure to enforce. An abutter can now say, hey, I think this is an enforcement issue. Code officer says, no, it isn't. That also becomes an appealable event, okay? So it's not just the violator, it's the abutter saying there's a violation, the code officer saying, I don't think it is. Those are the two enforcement kinds of decisions that are within that particular kind of appeal, okay? The second are variances, and there are several kinds of variances, and the test for each that you need to look at when you're looking at them is a little different, and we're going to go into those as well. And one big thing that I really want you to really have deeply entrenched in your mind about variances, and I'm not saying don't ever grant them, that's not what I'm saying, is that they are only to be issued, they have to be interpreted strictly. And that's both in the statute, it's in your ordinance, and it's in the case law. And the reason for that makes a lot of sense, right? You've seen your zoning ordinance that is enacted by the town meeting body. So that's the will of the people, that certain rules apply. So lots of sizes have to be a certain size, frontage has to be a certain size, buildings can only be so tall. And so the will of the people, that has been expressed in the zoning ordinance. And what a variance is saying, yeah, I know that that's what they say, but please give me, I don't want to do that, right? And so, yes, of course, they can be granted if certain criteria are met, but those criteria all must be met and they must be looked at strictly, okay? So that's kind of the rule of thumb when it comes to variances. And the third kind of appeal, and this one I will say, Arundel is unique. You are a unicorn in a special, special place, right? And I represent a lot of towns. And this third type of appeal, you're special. Never seen this one, or I haven't seen it. And this is basically where there are alleged errors in administrative procedure and or an interpretation of the land use ordinance. Now, I would hazard a guess that most of the time appeals of enforcement decisions involve an interpretation issue, right? But this is a separate, special kind of appeal. It's its own separate animal. And so I will say, and again, I think I've been representing the town coming up on 20 years. I've never seen one of these. I don't think. Have you? I don't think so. So if we, if we come upon, we'll cross that bridge when we get to it. But one thing to bear in mind is that if it's an error and an administrative error, and I'm not sure what that would be, maybe um, I can't even figure out what that would be. But in the event you find there was an administrative error, you can refer it back to the code officer or the planning board, okay? If it is an error in interpretation, you can find an error and you can modify whatever that approval was, assuming it's planning board or a building permit. But if there's a condition attached to that approval, again, building permit or planning board approval, you cannot modify the condition. What you have to do is remand it back to the decision maker to make a decision consistent with your interpretation of the ordinance, okay? Again, I'm not going to spend too much time on that one because I've never seen it before, all right? But again, if you see that coming across your desk and have questions, you know where to find me. All right, another threshold issues, meaning if they can't jump over this hoop, you don't hear the merits of the appeal. And that is, who can appeal? Not everybody. You have to, it's not a free for all. Only certain types of people can appeal. Similarly, not everyone can, well, that's an easier. Let's go through the appeal part. So only what is called, I'm using some finger quotes here, an aggrieved party can appeal. And we think, well, what is an aggrieved party? Well, conveniently, the definition is in the town definition section. So let's break that down. An aggrieved party is an owner of land whose property is directly affected. That makes sense. So if it's a notice of violation, my property, of course, I get to appeal. If it is a variance and it's my property, then of course I can apply for that. But can my mom apply for a variance for me? I mean, my mom would do anything for me, but if my mom came to you and said, my daughter, she's lovely and she deserves a variance, could she do that? She cannot. And the reason why is because of standing. Only certain people can come before you. Now, well, here's what happens. Like when the application comes to you and I think it probably goes to whoever staffs the board, which might be the code office or Ann but you're the, well, no, that's your determination. Yes, absolutely. So there, and that's important to know. And I'm glad you asked that question because you don't want to assume that somebody else has gone through that. So basically, my understanding, and excuse me, Keith, correct me if I'm wrong, the application comes into the town office. What the town office does is say, hey, here's the application. Is there a check? Yes. I know we have to schedule this within X days of receipt. Okay, and it's more of an administrative role. Is that fair to say? Yeah. So I think it's fair that somebody might identify that, wait a second, the owner of the property isn't the person applying. They may flag that for you, but it is this board's job to determine whether those basic jurisdictional issues, jurisdiction, standing, those issues are checked before you move forward. Okay. So this notion of standing of back to like my mom applying for me, there's this notion of right, title, and interest. And that's basically saying, does the applicant have sufficient right, title, or interest in the property to ask for what they're asking for? So what is that? We know a deed, that's the gold standard. If I can show a deed that with my name on it, an easement, purchase and sale agreement. I want to buy this property, but unless I can get the variance, then purchase and sale agreement, option to purchase, lease, those are all perfectly fine. You don't have to have a deed, a warranty deed to come before you. So that's the kind of thing you want to ask, if they have that kind of right title and interest. Now, here's a recent complication in that. It used to be that I would always advise, look, if somebody comes to you with one of those documents that I just mentioned, you're all set. You're a volunteer board, you're not real estate attorneys, you don't need to look behind that. That has been the advice for decades and decades. Enter a fairly recent case where that has kind of been called into question. So somebody who say, you've got the Hatfields and the McCoys and they don't like each other and they're the abutters and they don't want the variance to be granted because it means the setback is going to be closer than it should be to their property. And they raise an issue like, well, you know what? They don't even own that property. I have, a right of way, or, I have an adverse possession claim against them. Bottom line, it used to be that if they were fighting people, I would tell you, don't look at it. If they've given you those documents that I've mentioned, you're fine. Now there's a case that calls that a bit into question. And so I won't go into the details of that case, but if you get a situation where you've got an abutter or somebody who says they don't own it, I own it, or they don't have the right, or my easement allows me to go here, that's when, again, I'm not trying to perpetuate business for myself, but sometimes a call to the attorney for 20 minutes heads off at the pass a lawsuit. So think about that. All right. So if somebody's saying, whoa, 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 hold the phone, you might want to pick up the phone. All right. Okay. So that's the right title and interest. Aggrieved party. If it is somebody who isn't the property owner and they are coming to you saying, for example, code officer issues the permit and I don't think they should have issued it. So in order to be able to come before you, that person has to have what they call a particularized injury. And what that means is bigger than, larger than that of just John Q. Public. Okay. So an abutter, automatic standing. Somebody kind of maybe stone throw away, you want to think about what the application is for and could it affect them. Somebody who lives on the other side of town, do they have a particularized injury? They don't. Okay. So those are kind of the factual distinctions. There are often people in this town and in every town I represent that they are concerned citizens and they really don't like something, but they live on the other side of town. They don't have standing to appeal the issuance of a building permit or a planning board approval. Okay. So just keep that in mind. Let's see. All that. Okay, the last sort of threshold issue, we haven't even gotten into the merits of any of these applications yet, is timeliness. Okay. That is basically under your ordinance, they have X days to appeal a decision. Usually it's 30. So before they can come before you, you need to look and say, did they make it? Did they get over I don't want to say the finish line, the starting line within that 30 days? It is the case in many towns that if they didn't, even if they have the best case ever and it's really like compelling, you can't hear it. Except Arundel has a special provision that says you can waive that requirement for good cause. That, of course, you're going to ask me, well, what's good cause, right? And I will tell you that the courts recently have kind of made a distinction between good cause for missing an appeal deadline in a municipal context and if it were going to court. Very different, much more charitable, a little bit more lenient on the municipal board side. Whereas in courts, it's basically like the dog ate my homework is not going to work. It has to be a very, basically a big deal in order to avoid an appeal deadline to court. But in a municipal one, you have some discretion there. So the kinds of things in the case law that have warranted a local good cause exception is this classic snowbird scenario, right? I'm a summer resident. I was off in Florida. I came back. There was a house next to my, I wasn't aware. I wasn't notified. And Keith, I'm looking to you. I don't know if this is the case. Some towns to kind of head off at the pass. I don't think Arundel gives those cards, the abutter notifications, do they, for building permits? I know for planning boards stuff,
Yeah, planning stuff, subdivision stuff.
right? But not,
Not in general.
yes, right. And so some towns do that, some towns don't. And the reason why some towns do it is so that they can try to head off at the pass those arguments. But the administrative nightmare and the cost of it often cannot be borne in smaller towns. So that's one of the reasons. Or, God forbid, my husband was having chemo treatments in Boston. We missed it, those kinds of things. So, you know, there's some leeway and discretion that you can exercise. And your decision, if you decide, yes, there was good cause, it won't be overturned by a court unless it was like a total abuse of discretion that you did. So there you go. All right. Other threshold issues, again, before we get to the merits. Conflict of interest, bias, you've heard about these concepts. We kind of know what they mean. Viscerally, we know it's everybody's entitled to have a fair and impartial decision maker, right? So what does that mean? What does conflict of interest mean? What does bias mean? They're interrelated. Again, they're all related to this notion of due process, that everybody has the right basically to a fair day in court, and you're the judge and jury, right? So conflict of interest, it kind of depends on what source. There's statutory definitions, there's local definitions. Some towns have conflict of interest policies, but the bottom line is this. Conflicts relate to money. If I have a financial interest in if I'm a board member and I have a kind of financial interest in what's before me, bias is more relationships, okay? So conflict of interest under statute basically says if you have and again, I'm throwing legal jargon at you, but an indirect or direct pecuniary interest, what does that mean? That means that if you own 10% or more or shares or whatever of the business or entity that's coming before you, you have a conflict, okay? Now, I will tell you that if you have, I have 9% of an interest, those are the kind of things when you start parsing those definitions, I think the best recommendation always is disclose and recuse, okay? Or disclose and don't recuse if it's something that your fellow board members don't think it's necessary. But it's always best to disclose it, have a discussion about it, and move on. And the reason why this is important is because if there is a legitimate claim that there was conflict of interest or bias, then the entire decision can be voided. Now, that's also in the situation where there's a completely unanimous decision, and one could say, well, it was unanimous. What difference does it make? They didn't carry the day. The thought is that any discussion or deliberation that tainted board member could have kind of swayed their fellow board members, and you don't know what's in the minds of your board members. So I love it. Thank you. That was a soft toss. I appreciate that. No, it does not. So it can, if you say, I feel like I cannot be fair and impartial, I recuse myself. Your fellow board members are not going to say, Paul, we know you. You can be, fair and impartial. We want you. No. But alternatively, if you know that Paul has an interest in this and he hasn't reported it, I'm kidding, right? That's not what's happening. But I have seen many situations where there's a conflict or a bias, possibly. And the person, usually the chair will say, does anybody have a conflict? And everybody says no. And awkwardly, another board member knows that, heck yeah, they have a conflict. It's their brother or their, business partner or college roommate. They still go drinking at Bennett's every Friday night, and they don't disclose that. Believe it or not, you have a duty to raise that. So and this is kind of awkward and difficult, but if you have a concern around that, sometimes it's best to reach out. If it's a chair, not that the chairperson has the, but just to discuss that, because sometimes it's great to have an executive session on that. So you can have that discussion outside of the public and that person can decide to recuse themselves without having that whole melodrama in public. Now, if you believe that you have a conflict and you don't want to, or are biased, and you don't want to talk about why, you absolutely don't have to. You can just come up here, say, I have a conflict and I need to recuse myself. Done. If you have, oh, I'm not so sure. College roommate scenario. You come up, say that they were my college roommate. I haven't seen them in 20 years. I think I can be fair and impartial. Again, no one can fault you for raising that and moving on and not recusing yourself. It's also an opportunity for the applicant to say, I object, or somebody who's the abutter says, I object, they can't be. Because the whole point of this is to raise the issue in open court, so to speak, so that we know they can't, if they don't object, it's a forever hold their peace type situation. They can't later, they don't like the decision that you've made, say, whoa, wait a second, he's biased, he shouldn't have participated, right? It's kind of the no takesies backsies. You can't, because some people want to hedge their bets, right? They think, oh, they could be for me, they could be against me, or, given the numbers, there's only 4 people, I want as many bodies to hear my case. And they want to hold off to the end and say, oh no, he's biased or she's biased. You can't do that. As long as you raise it at the outset, right? And give everybody an opportunity to weigh in. Okay, so bias, again, relatedly, that is not about a money thing, it's about a relationship. And under statute, it actually talks about if you are related by blood, and this is a word, I don't know if I'm going to be able to pronounce it, but by 6th degree of consanguinity. Okay, well, what the heck does that mean? It's a small town. Everybody's probably related to the 6th degree of consanguinity. So the bottom line is half of the people are cousins twice removed. Again, you can say, we're cousins. I haven't seen them in 30 years. I can be impartial. That's totally fine, but just raise it. Okay. The other thing I want to mention is that even if you don't rise to the level of that 10% interest, or, you haven't seen them since you were 10, the cousin, back to this notion, it's not just actual conflict, actual bias, it's perception of, right? And that's in the not in the statute, that's in case law. So if there could be a perception that you are, that could also taint it. That's why the disclosure is important. Open discussion, recusal if appropriate, or no, we're just gonna move on, but just get it out there in the open, okay?
I have a question.
Yes, please.
What if they don't know that person is their second
Yeah,
cousin twice removed?
Then how can there be bias, right? If they don't know? Well,
Yeah.
exactly, right? It's small town, we're gonna be related to half the people in it and you don't even know. But the
Yeah.
whole point is that relationship would make you impartial. If you don't know you have the relationship, then there's no good argument
Okay.
there. All right.
And that's why I mentioned that, because Tia probably has first cousins twice, 3,
Mhm.
4 times removed in this town, all over town, and she has no idea
That's
who
right.
they are.
And so if somebody gets up and say, by God, I know that's your cousin, you can
Yeah.
say, well, didn't know that, and I can be fair and impartial, but then you can look at the board members, and if they say, might as well. I think that would be fine, but it's very fact specific, right? Okay, so here's another, again, one more, we're gonna be done. Sometimes an appeal, not often, but it's complicated, right? And it might take you more than one meeting. So what if you have a situation where you weren't there for the first meeting, but you're going to be available for the second meeting? Can you participate in that second meeting in the decision? Answer is yes, if. Okay. So I know Keith is diligent about recording. And so if you can say at that second meeting, I've watched the video, I've looked at all the documents, I'm well acquainted, I think I can, I'm well informed and I can make this decision. As long as you state that on the record, then you can participate. Okay. All right. We have gotten through finally the threshold issues. Let's go to the decision-making process, okay? First and foremost, this is a fundamental concept that the applicant always bears the burden of proof, always, whether it's an appeal, whether it's a variance, whoever's before you must make their case, right? And so the bottom line is, all right, fine, what's my job? Your job is to look at A, what kind of appeal is this? B, is this a variance? And then look at all of the evidence that is being presented. And when I say evidence, that's both paper and, you know, the people get up and they make their case. Or they have witnesses. That is the evidence. And so you look at what the standards are. Variance, easy. We'll talk about those standards. Undue hardship, the test is very clearly lined up for you. Have they presented you with sufficient information that allows you to say yes, yes, yes? And if they haven't, then you deny whatever it is they're asking for, okay? And how do you do that? Like I said, you look at what's in the record. And when I say the record, that is the full, that's written testimony, you know, the application itself. Code officer will probably have something to say about it. You know, neighbors may very well have something to say about it. So the entire thing is the totality of the record, okay? Now, one thing, I'm going to tell you two things you cannot do. I'm sure you know this, but it's hard, right? Especially, and I know, Velma, I'm sure you know this, that when there's a room full of people who feel a certain kind of way about something, and it's very, you know, like the things they're talking about are, you know, well, the children and the budget and taxpayer dollars and, you know, all of that kind of stuff. Those, even though they're really compelling and important and significant, if they do not relate to a specific criteria that you're supposed to be looking at, you kind of had to do this, right? So when you see a room full of people, it's not a popularity contest. If people say, I have seen this happen in boards where they will literally say, well, we have 20 emails in support. We have 40 emails against. That's not relevant. Of course, the content of those emails is very relevant. If of course they address the criteria that you're looking at, but it's not a popularity contest, right? You have to look at the ordinance, not public support or opposition. Another thing that is really hard because we're all human and we have opinions and feel certain kind of ways about things. Again, your own personal opinion as to whether or not something should be granted has to be irrelevant. You have to look at the ordinance because that's what the town's voters has told you that are the criteria that you need to look at, okay? And that's back to that bias piece. If you're like, I cannot be objective, then you can just recuse yourself. And arguably you should recuse yourself. I had a case where there was a woman who basically was a member of a board who publicly stated, there's no way in hell I will ever vote for this kind of application. Like, okay, so that, and of course, I got the case after the decision was made, right? But that decision got completely tossed because she kept sitting on the board. And remember, I was talking about that tainted decision, got flipped. Or not, it didn't get flipped, it just got canceled. So these are the kinds of things you want to think about. All right, what are the standard of review? I don't know if you've heard that term. That's a legal term. What's the standard of review? Meaning, when I, board member, am looking at an application, what do? Do I look at only what the decision maker had in front of them, like code officer, planning board? I only look at what they had. That is what they call an appellate standard of review, meaning you're the appeal body. And of course, your name is the Board of Appeals, so you would think, okay, that makes sense. That's not what your review is. Your standard of review is what they call de novo. That just is Latin for do-over, from scratch, tabula rasa. You look at it fresh, which means you're not bound. You don't have to have deference to the board or code enforcement officer decision in front of you. New day, everyone puts in their evidence, and there is evidence. It's not just what was before them. You can have new stuff in front of you, okay? Now, if your decision goes to court, say somebody challenges, and then the Superior Court, when they're reviewing your decision, does have an appellate standard. They're only look at the record. There's not new stuff that can be introduced at that point. Okay, so one other thing I should talk about is constitutional issues or if we talked about you're not supposed to necessarily be interpreting deeds and restrictive covenants. Constitutional issues, you probably heard this before. People will say, you're violating my constitutional rights. This is a takings. You're taking my property away from me, or, you're treating me differently. So you're denying me the equal protection of the law because I'm fill in the blanks, whatever that enumerated reason is. You do not have the authority to deal with constitutional issues. They have to raise them if it ever goes to court. So you'll hear it, but you can simply politely say, thank you, noted. We don't have authority. We're moving on. Okay, let's talk about variances, because I think that's a lot of what you probably will be asked to be looking at. There are different kinds, and each of the kinds has slightly different criteria. So let's talk about those. And it's back to that idea, you can only exercise that authority that's specifically granted to you. And I'm going to reiterate this. I apologize. I'm beating a dead horse a little bit, but both the statute and the land use ordinance and decided case law on variances basically say, you'll see there's probably 4 or 5 different prongs under this hardship test that we're going to talk about. They have to meet each and every one, and say they meet all but one, still must deny. Okay. Okay, so let's talk about the kinds of variances. There are 5. One is just garden variety variance from dimensional standards. What are dimensional standards? Lot size, frontage, setbacks, height, lot coverage. Okay, that's what a dimensional variance is, and that's kind of the bulk of what you'd be dealing with. And those are the toughest. We'll talk about the standards. That's the hardest to get. The second is allowed by state statute, and Arundel has decided that they want to have this kind, which is a little bit more it's a kinder and gentler variance, and it's specifically for setbacks, just setbacks, not frontage, not lot size. Setback variances for detached single family dwellings. That's if somebody wants to bump out, right? And it's very limited to circumstances where it's your primary residence. Okay, you got to live there. It's not an Airbnb, it's your primary residence. Okay. There's another kind, again, 20 years. I've never seen them. I'm going to spend no time on them, but there are variances for telecommunications facilities. We're not going to spend too much time on that. If it comes up, we'll deal with it. Then there are these disability variances, and that's a statutory thing, which basically allows you to grant variances from setbacks and such for access and egress, hand railings and ramps and those kinds of structures. And then in your own ordinance, there's a shoreland disability variance. So we're going to go through these. All right. So importantly, here's the criteria, right? When it comes to these general dimensional variances, and you'll see in all of these, you'll hear the term, and when I say all of these, meaning in pretty much all of the variances, you'll hear this language called the undue hardship. Okay. And that's defined a little bit differently in the various ordinances, but under state statute and under your own ordinance for these general dimensional variances, here's the test. Okay. So it's a 4-pronged test, and actually in Arundel it's 5, but the first one is often the hardest one to surmount. Okay. Basically, the applicant has to prove, because it's always the applicant's burden, that the property cannot yield what they call a reasonable return without the variance. Okay. Now, understand that the case law is very, very clear. Back to what I was saying about the strict application, is that reasonable return doesn't mean maximum return, right? So in that case, if people are coming to you for like a renovation, an expansion, a new deck, just by the case law, they can get a reasonable return on their investment without a bigger family room or a deck. Okay, those, I think the case law will tell you that you really need to reject right off the bat. Now, different scenario if it is a lot, unbuilt lot, and without the ability to put some kind of structure on it, they can't do anything with it. That's a different kind of analysis. And even then, it's still, there's case law out there that says, maybe not. But to me, that's a much better case that you can't get a reasonable return on your investment if you can't build anything on there. Okay. Let's see. Okay, so I'm going to talk to you about findings and conclusions, and I'm going to raise it in the issue of these different criteria. As you may or may not know, boards who are these quasi-judicial boards, meaning you're issuing a decision, right? Much like a court. You have a duty under the Freedom of Access law to make written findings, okay? Basically, this is what we decided, and this is why we decided it. Now that, for example, if it's a variance, you can't just say, we grant the variance because we find all of the 4 criteria of the hardship test met. That's, if that gets appealed, court's gonna say, we have no idea why you decided what you decided. They will remand it back and you'll have to have a do-over, okay? So, for example, a finding on the hardship criteria that we just talked about, sorry, the reasonable return criteria, you could say, we find that this criteria has not been met because there has been no evidence to suggest that they have tried to market this property and have not been able to, right? That's a reason why. That's you've got to thread the criteria and the evidence and say why you decided what you decided. Alternatively, say you do want to grant it and say, we find that the reasonable return criteria has been met because they have marketed this property for 10 years unsuccessfully and no one will buy it. So those are just examples of how you make those findings and conclusions on these different criteria. Okay, first criteria, reasonable return. We talked about that. The next standard requirement on these variance hardship criteria is that the need for the variance is due to the unique circumstances of the particular lot and not the general conditions of the neighborhood. Okay, so here's a classic scenario. You have somebody saying, I need a variance, I need a variance. And you look at the tax map or the GIS and you see that every single lot in that area looks exactly the same or very similar size, similar topography. In that case, you can't grant the variance because there's nothing unique about that lot. Now, alternatively, you could look at that map and say, wait a second, this is like just a tiny little postage stamp lot. It's a non-conforming lot, but at the time it met zoning and it's surrounded by all these bigger lots. Or it's the same size, but there's ledge everywhere or wetlands or that kind of thing. You've got to find something that's unique that would warrant this. Because if every single one looks exactly the same, then that's not unique. Okay, does that make sense? Right. The next criteria is that the granting of the variance will not alter the essential character of the neighborhood. Classic example, they want to build a skyscraper and everything's a cute little cape, right? That's a bit extreme, but that's kind of giving you a sense. So how do you know what the essential character is of the neighborhood is, right? Recent cases come out of the law court, which talks about, well, in your ordinances, usually there's a purpose section for every zoning district, right? So that's helpful. It used to be that people would think that the neighborhood is just kind of that little cul-de-sac or the little properties surrounding. And that could be the case, but you can broaden your lens and look at, the purpose of that district. You can also look at, and the court has said you should and must look at if it's in a shoreland zoning area. That's an essential character of the neighborhood. So these are the kind of things that you can look at when it comes to that. And sort of that final, you've probably heard this notion of self-created hardship. That basically means that if you are the reason why you're asking for this variance in the first place, no, thank you. You can't come to us. Classic example. And people do this even though they do it unintentionally, and then they shoot themselves in the foot, where say they had a lot, they divided it and made it non-conforming. They were the ones who did it. in that case, they are out of luck. They cannot come to you. And basically the question is, or the ask is, save me from myself. That's not, you can't do that. Okay. So, here's a scenario I face a lot in towns that they've done just that, or they've made a mistake, or they realize, oh, shoot, I need a variance. Say they built their shed and it's, into the setback, then they come to you and say, oh, please, can I get a variance? Do you give them a break, or do you have to apply the criteria exactly as you would to somebody who's asking for approval, not forgiveness, essentially? The answer is you got to apply the same standards in the same way. Okay. All right. Next is that kind of kinder, gentler variance for basically those single family dwellings, and it's just a setback variance. You can't ask for a frontage variance or anything like that. Then you'd have your general variance that we just talked about, which is the harder one to get. Okay. So for these detached single family dwellings, like I said, it has to be their primary residence. And let's talk about, they also talk about undue hardship, but the test is a little bit different. So I'm going to go through those, and that's in, where is that? Your setback variances. So that's 11.4.2 of your ordinance. And again, I'm just kind of going through these criteria that are very clear and they're in front of you, but I want to flesh them out with kind of examples and what kind of evidence would serve to either allow or disallow these variances. Okay. So people can ask you for up to a 20% variance from the setback. And here are the criteria. Again, similar, you've heard this before. The need is due to the unique circumstances of the property, not the general conditions of the neighborhood. We talked about that. That's the same. The granting of the variance won't alter the essential character. We talked about that. That's exactly the same. Third, hardship, not self-created hardship, also the same. These last two are a little bit different. The granting of the variance will not substantially reduce or impair the use of abutting properties. And that makes sense, because if it's a setback variance, it means you're going to be a lot closer to your neighbor. So the neighbor might have something they want to say about that. And let's talk about when you could grant it or not. Say they'd say, you know what, we're going to plant arborvitaes and it's not going to bother them, and there's going to be a nice little buffer, or the abutter won't be affected because their house is totally on the other side of the lot, or it's shielded from view. These are the kinds of evidentiary things that you will, if you say that criteria is met, make sure in your findings you state why. Okay. And the last part of this test would be granting of the variance is based upon demonstrated need, not convenience, and no other feasible alternative exists. Again, those are pretty strict, right? It's not like, oh, I could really, we just want a bigger room, that's convenience. That's not need. I'm trying to think of a scenario where, okay, we're foster parents and we're fostering 10 children, and you can't fit all these 10 children in this one area. It's need, it's not necessarily convenience. And no feasible alternative exists, because in order to find a place with 10 bedrooms, it's going to cost us $1 million, where this would only cost us $30,000. Those, and again, I'm making these things up, but I'm just trying to give you examples of the kinds of evidence that would have to be put in order to say, yep, that box is ticked. Okay. Okay. Communications facilities variances, we are not going to talk about those. Disability variances. Okay. This is something where you don't have it specifically in your ordinance, but state statute, for obvious reasons, allows folks who need a departure from, say, a setback variance to build a ramp or handrails, or a carport, to help them get safely to their home. So again, they can only be granted if you're trying to make the house more accessible for the resident. And it must be restricted solely to the installation of these types of adaptive or accessibility type structures. Now, you can condition it on basically the resident still being an occupant of that. You can make those things be removed. You don't have to, but you can specify as a condition that you want those things removed when the resident who needs them is no longer there. Okay. And related to these disability variances, you have an actual provision in your shoreland. It's not in this section 11, but section 8 dealing with shoreland zoning. It's essentially the same, but a little bit stricter, that you have to notify DEP if it's in the shoreland zone and this kind of variance is being asked for. And you have to limit whatever you're granting to the greatest, to allow for compliance with shoreland zoning to the greatest extent possible. Okay. All right. Findings and conclusions. I kind of talked about that. The importance of them, why we do them. Well, statute requires it. Also, if you're appealed, the court is going to need to know why you decided what you did. And so if you're not clear, they're going to bring it, they're going to remand it back. We've talked about what those are, and it's basically a dance, right? What's the standard? What evidence has been presented or not presented? Dovetail them. So for each of those criteria, you want to say, we find this to be met because, we find this not to be met because insufficient evidence was presented to us on this particular criteria. Okay. And I just want to impress upon you, you need to make findings on each of those individual prongs. You can't just say the undue hardship test has not been met. You want to go through reasonable return, unique circumstances, essential character, and go through each one of those things. Okay, post-decision issues. You've made your decision, you think, all right, we're done, right? Just a few things to be aware of. If I don't like your decision and I'm the applicant, I can ask you to reconsider that decision. And bottom line is there's the whole process of reconsideration, meaning asking for it and making the decision must be completed. Even the state statute says 45, Arundel says you got to do it in 30. Okay. Now, what does that mean? Somebody says, please reconsider. Do you have to reconsider? No. Do you even have to hear what they have to say about the reconsideration? No. So you can basically say, here's what has to happen. I come before you, I make my application. I want you to reconsider. Please, please reconsider. You have to schedule a meeting on the reconsideration. But what has to happen is somebody has to say, I move that we reconsider. So if nobody moves, it's crickets, game over. If somebody moves and there's no second, it's game over. But if they, not to say that you, if you realize, say something happens that they say, oh, I failed to mention, or I guess you didn't realize, or you made a mistake and you realize, oh, maybe I did. You can absolutely reconsider your decision as long as you do so within 30 days. Okay. Another post-decision thing is appeals. Just like I said to you before, where you can't hear appeals if they don't come to you within a certain period of time, the court cannot hear if they don't come within a certain period of time. So I believe they have 30 days or 45 actually under the statute. But importantly, the reason I point this out is because in your notices of decision, you have to articulate the path and deadline for appeal. Okay, so that should be part of your forms. Other things, if it's a shoreland variance, again, you got to notify DEP of what your decision was. Another thing that people forget, and I've seen this happen, like 10 years later, 5 years later, when they're trying to sell a property, is that under statute, if you grant a variance, they have to record that in the registry within 90 days of it being granted. And if it's not granted, excuse me, not recorded, even though you gave it to them, it's void. So, and that can be a problem, as you can imagine, years later when they think they're all set, they built something and the variance was actually void. Creates all sorts of headaches. Another thing is, can somebody come before you with basically the same request? They can't within 2 years, unless, of course, there's been some substantial change or new evidence comes to light. All right. So next topic is freedom of access. And I don't know what time are we at here. Okay. Okay. Yeah. And Keith, tell me this. Do you do general, sometimes I think boards do general FOA training and all the boards come, I don't want to overdo people's patience, but.
We haven't done, well, put it online.
Okay, perfect. Yeah. So I mean, I don't have to go through this if you'd rather not.
Yeah.
I kind of led out with your individual requirements, but can I just, let me give you like the real thing that I'm concerned about and that I've seen happen, just so you know what I won't give you the definitions and whatnot, but there is this, so on the one hand, you have public proceedings, which is what your meetings are. And then the other hand, you have public records, and that's what freedom of access law is. It's basically all of that, both public proceedings and public records. People should be able to see them and know what's happening. What's happening now with the advent of emails and social media is that they bleed into each other. That you think my email is simply a public record. Well, if you're talking about an application and the substance of an application in cyberspace, that should be a public meeting. And so that's a violation of the public meeting laws, right? So when you get an application, Keith sends it off to you, you can absolutely talk about, and I'm sure Ray did this. I'm sorry, I can't make it tonight. I'm sick. Totally fine. Say that was a variance or an appeal. Absolutely can do that. Talk about logistic stuff, but you cannot talk about the substance of the application. I don't like this. I don't think it should be. This is a problem. It's not timely. It's fill in the blank. Those cannot happen in cyberspace. Another thing that happens unintentionally is Facebook, right? Social media. People start commenting on a particular application, and maybe Paul, you commented way up here, and 2 days later, you might make a comment too. Didn't realize that your fellow, first of all, you shouldn't be talking about an application anyway. But if you do, that's if a quorum of the board is talking about anything outside of this room, don't want to do it. The only other things I will say, emails, texts. If you are texting or emailing about something, and I don't think, do members of this board have town emails? Or they use their own?
They don't have any, emails.
Right.
If you, project.
So what I'm saying is that if there's a records request, you have the fun of being the access officer, right? So if somebody wants records, they will ask Keith, and he's the one responsible for compiling them. But remember, if you're emailing, they're record retention rules. You can't just delete it, right? So you have to keep those. Most of the time, the town will be able to get them because they're usually generated from the town. But if you're emailing each other, they wouldn't necessarily have that. So keep those emails. Also, here's the trap for the unwary. Oftentimes we have our phones and it's a really long meeting and it can get really, right? So you're texting, hi honey, I'm gonna be 20 minutes later. Can you pick up some milk on the way home? That kind of thing. With the ever, more suspect people, they're texting about the application, right? Or they'll see somebody in the audience texting at the same time as you are, and they're convinced that you are texting about the application with somebody in the audience. You know what I'm talking about? This happens. The reason I mention this is because if that's the case, someone makes a records request, anytime you're texting about anything of a matter of public business, that's fair game. And if it's not produced, they can ask for a subpoena from the court for your personal devices. So what I'm saying is keep it clean. Don't give anybody an opportunity to, have those kinds of thoughts and make requests for records. But any records you do have relating to this, make sure you keep them, okay? And that's really, we can forego all the other stuff.
It was provided,
I missed that. I didn't see that.
yeah.
Uh-huh.
They had removed that,
Oh,
so there were sanctions coming.
so that's a double whammy. Not only are you not supposed to be communicating in email world about substantive things, you didn't retain the documents. So that's bad. And when I say that's bad, as far as fines under the FOA, it's really nominal, but that's not the issue. The issue is attorney's fees. Okay. And the only other thing I'll say, and it sounds cheesy, but I call it the Portland Press Herald or the New York Times principle. Before you press send on any email, look at it and think, do I want this to be on the front page a la Lewiston? It happens. We all get careless sometimes. I get impatient myself. We get frustrated. Those comments that you toss off just out of frustration, can come back to haunt you. So read it. I also, if it's not urgent, 24-hour rule, wait. If you're steamed about something, read it again. Don't press send because for obvious reasons. So that's it. No more finger wagging. That's all I've got. Okay. There, yeah. Worse. Yeah, always a pleasure. And I hope you'll never have to use any of these things that we've talked about. But it's smart to do it beforehand, like so you don't have to have an executive session for an hour before an application.